Welcome to Southwest Florida Real Estate Update, hosted by local realtors Jim, Michael, and Morgan York of the York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, featuring the leading experts in the real estate field.
Hi, welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Real Estate Group, and today we're joined by our host Jim York and his guest Celia Deifik, attorney with the law groups Liens and Deifik.
Thank you, Morgan, for the introduction. Well, thanks for coming on the show today. So let's tell us a little bit about your background and your practice here and being an attorney for real estate litigation here in Naples.
Yes, I'm board certified in real estate and have been certified by the Florida Bar since 1990. I practice with Liens and Deifik downtown, and I focus on real estate litigation, some business litigation, and things have really been popping since Hurricane Irma.
Yeah, I believe it. And whereabouts is your office down there?
Downtown in the Capitol Bank building, corner of 6th Avenue North and 41.
Okay, well, you're here today. We're going to talk about liens, and there's all different kinds of liens that people can put on a property. And with all the new construction going here in Naples,
and a lot of renovations since the hurricane.
Renovations, and then the hurricanes itself. People have had liens put on their properties and maybe not even knew they had a lien on their property.
They should have been served, but it does happen that they are unaware of it. Yes, so when a contractor does work, or subcontractors, suppliers, and they work hard and they're entitled to be paid, Florida law provides some protection for them in the form of giving them rights to lien your property, and they can lien your property even if it's homestead. Now, what a lot of people don't realize is that the construction lien law is very convoluted and very complex and very specific. And contractors, lienors, are only entitled to a lien if they dot every I and cross every T. So there are a lot of opportunities for a unit owner, if the unit owner does not agree with the amount of the lien or the fact of the lien, to challenge the lien.
Well, let's first, before they challenge anything, let's walk them through the steps that a contractor has to do to file a lien, so they understand that. So what is a notice of owner, for instance?
Well, a notice to owner is generally something that a homeowner will receive from a subcontractor that they may not be aware of. So let's say that you have contracted, you're the homeowner, and you've contracted with Acme Contracting, and they're going to gut your house and do a rebuild. They hire a plumber, they hire an electrician, they hire a tile guy. You may not know these people, and you don't know that they're working on your property. So Florida law gives them an opportunity to introduce themselves to you, and that in and of itself does not constitute a lien. So the plumber, once he gets the call from the general contractor, may send out a notice to owner to you saying, hey, Mr. York, I'm going to be doing the plumbing work in your house. I might have lien rights if Acme doesn't pay me. Hoping that they will, but just want to let you know. Now, generally, that plumber, electrician, drywall person, whoever, won't even enter the property unless they see that a notice of commencement has been posted on the property. So a notice of commencement is a different piece of paper, and when a contractor gets ready to do the work and gets the permit done, and actually this goes right through the county planning department these days, the owner signs the notice of commencement and it's put with the permitting department. When the permit is issued and they're ready to do the work, the county sends it over to the clerk to be recorded in the land records. The contractor gets a copy of it showing the recording information, puts it on a post by the house, and that gives comfort to all the workmen who come on the property, because they look at that and they say, oh, look, I have lien rights, I'm going to get paid.
Right, and in that notice of commencement, it has the contractor's name, the owner's name, what their address,
Right.
plus if there's a mortgage,
The lender's information.
information. So that's all posted
So
there.
everybody has all that information.
So the next thing that we were talking about before the show was you have to be a licensed contractor and
Yes.
put a lien on a property. So maybe just go into that a little
Sure.
bit.
We have a lot of unlicensed people going around the county, particularly throughout Florida in the wake of the hurricane. We see this every time there's a storm, offering to do work more cheaply or for cash,
That's right.
whatever. Now, if they lien your property, it is an invalid lien, and it can be challenged, because in order to be valid, the work must be pursuant to the contract, it must be done by a licensed contractor, and it must be done with a permit, and it must be substantially completed. And it also must be filed timely. So there's like a checklist
That's
here.
right.
So if you are the owner, and I'm not encouraging people to willy-nilly challenge liens,
Right.
but if you truly feel that the lien is improper because it's for the wrong amount, or the work was not completed, or remedial work remains, or a variety of reasons, then you are entitled to challenge that lien. And the Florida courts and the Florida legislature lean more towards the property owner than towards the contractor as far as the lien rights.
So to have a valid lien, you also have to have a contract with the contractor, true?
It can be an oral contract,
It
but
can be.
most of the time it is a written contract. But when I say it must be pursuant to contract, if I have hired someone only to do plumbing work, they cannot lien me for building a wall unit or something totally separate. And the time frame will run 90 days generally, and there's exceptions to everything in this law, from the last time they did work on the property. And there's a lot that goes into defining what was the last work on the property.
And how do you verify that?
Well, many contractors keep logs.
They do.
In condominiums and homeowner associations, often the property manager will keep a log of workmen coming in and out of the property because they have to give them access. So now once a lien is filed, it will be good for 1 year, and that means that the contractor, and it can be a plumber or an electrician or a
That's right.
supplier, must bring a lawsuit to enforce that lien within that 1 year period. Very valuable tools in the statute for property owners are ways to challenge the lien that compel the lienor to act more quickly. And this can be very advantageous where a lien has been placed only for the purpose of leverage. Well, I'll show you, I'm going to put a lien on your property.
Right.
So if you force the lienor to put their money where their mouth is, oftentimes they don't come through and you can get the lien discharged, or it will give you an opportunity to negotiate it in a more advantageous setting.
Okay, well, we're going to continue this conversation,
Sure.
and then we're going to talk a little bit about how the homeowner can challenge it.
Sure.
We'll be right back
Okay.
in 1 minute here. Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Welcome back. Well, let's talk about how people can challenge the liens, because I think that's a process that most homeowners wouldn't know how to do.
Sure. There's a cheap way and there's an expensive way. The cheap way is you record a notice of contest of lien. That'll cost you less than 20 bucks, unless you have an attorney assist you, which sometimes is useful. And when you file a notice of contest, that means that the lienor must file a lawsuit on his lien within 60 days. If he fails to do that, he will lose his lien rights. The more expensive way is, and you're pushing the burden on him to start a lawsuit.
Exactly right.
The more expensive way is you can initiate a lawsuit and have the clerk issue a summons to show cause, which gets served on the lienor and tells the lienor, whether it's a general contractor or a plumbing contractor, that they have to file suit. They can do it in your suit.
That's right.
They have to justify their lien within 20 days. They must file something to enforce their lien. They can't ask for an extension.
They can't.
They can't bring dilatory motions like motion to dismiss.
That's right, all that, right.
If they do not do it within 20 days, they will lose their right to a lien. Now, if they file a counterclaim saying, here's why my lien is valid, then you're going to need to litigate it. But you'd be surprised how often the ball gets dropped.
But within a year, they have to file litigation, don't they?
But if you do one of these two things,
You
they no
don't.
longer have a year.
Exactly, if you want to speed it up.
Right.
And basically, that's a lot because maybe they're selling the home and the title is clouded or whatever reason.
Or maybe you want to hire another contractor and they're unwilling to come on because you've already got a lien. Maybe you want to refinance your mortgage. Maybe you just don't like having your title clouded.
So the next thing we were talking about, obviously, before the show here again, was how can people do a little search on their own to find out if there's a lien, rather than having a title search done by an attorney or a title company?
Sure. That's actually very easy in this day and age.
It is.
At 3 a.m., you can sit down at your personal computer or your iPad, go on to the website of your local clerk of court. Here it would be the Collier County Clerk of Court. Click on Records Search. There are two different types of record searches. One is court records, and the other is official records, sometimes called land records or public records. Click on Land Records and put your name in. Now, you can refine it with a drop-down menu.
You can,
and
right.
look for liens. But especially if your name is not particularly common, just leave it at all documents, and it will show you every document recorded in the Collier County land records involving your name. Now, if you're an investor and you've been flipping a lot of properties, you'd want to have a more refined search.
And you can do it by date too. You can go back a year or 10 years
it's
or
very
whatever.
intuitive.
Right, it's
really
very good.
Right.
So the next thing, we'll take a little break here, and we'll talk about arbitration.
Sure.
And then we'll continue from there, okay?
All right.
We'll be right back in 1 minute.
Thinking of buying a home located in a golf course community in the Naples, Marco, Bonita, or Estero, Florida? Here is what Mark Lai, former PGA winner, says about Realtor Michael York of the York Real Estate Group of Downing Fry Realty.
Hi, I'm Mark Lai. If you have any real estate needs in Naples, Florida, the one company to contact is the York Real Estate Group. Also, if you want a golf course property to invest in, Michael York of the York Real Estate Group is the guy to contact. Michael knows every golf course in Naples. I will tell you this, he's been in the golf business for a long time. He's played all the great golf courses down here, and he is an outstanding realtor. I've known him for quite some time, and he's he's got a lot of integrity, and he very much knows his stuff on all the different clubs here in Naples. So the York Real Estate Group is a great place to start. So if you have any time or anybody that wants to visit down here in Naples and look at the options out there, please contact the York Real Estate Group.
Welcome back. Well, let's talk about our options of arbitration. So let's just go step through that. Some of them have it in the contract, right?
A lot of not just contractors, but more and more commercial enterprises have arbitration provisions. And arbitration provisions can be binding. However, in the narrow sense of whether a contractor can get a lien or not, whether it's an invalid lien or a fraudulent lien,
right,
which is a very big topic, that has to be done by the court. So if an owner challenges a lien, for instance, does an order to show cause, has the court issue an order to show cause why this lien is not fraudulent or invalid or something like that. And the contractor comes back and says, oh, wait, we can't do this in court. We have an arbitration provision in our contract. We're going to have to go to arbitration, and that'll take all this time. No, the courts have said there's a lot of things you guys can take up in arbitration, but the fact of whether you're going to enforce this lien or not has to be determined by this court. And so that needs to be done here. I think something else to realize is if an owner shows that a lien was invalid or fraudulent, those are two different things,
right,
and we'll talk about them in a second, then the contractor can lose the right to lien that job at all. He can't just say, oh, I made a mistake, I'll amend. Now, for honest mistakes, miscalculations, the court will let that slide. But if a lien is willfully, egregiously high, like he knows you only owe him $80,000 and he's liened for $200,000, and he gets caught doing that by the court is going to say,
throw it out.
You're not going to even have a lien for $80,000. Invalid lien is a little bit different, although sometimes they overlap.
Before you go into that,
Sure.
I don't want to interrupt it, but they can't put a lien on for profit either, right? That's
No,
what we were
they
talking
can't.
about before.
They cannot lien for profit and overhead. They cannot lien for work done without a permit. They cannot lien if they are themselves an unlicensed contractor, and they cannot lien if they haven't substantially completed the job.
Exactly, okay.
Right, so
we're going to continue on that conversation, arbitration options.
right, so I think that people get intimidated by these contracts, and they get intimidated by the liens. And if they would sit down with an attorney, they might find they have a lot more options than they think, and that often the contractor may have put the lien on thinking, well, they don't know, they're going to be intimidated and
settle.
Right. Whereas, and contractors earn their money, I'm not saying they don't,
That's
but
right.
there are some bad apples and there are some serious misunderstandings. So if a owner takes the time to challenge a lien and force the contractor to defend their lien, then they can get it worked out and get their attorney's fees back for bringing a order to show cause, and also get damages where necessary. If they had to bring someone else in to redo work, if they've missed the winter rental season, which is why I say to people, really, you want to have a time frame in that contract and provide for delay damages, or at least provide a promise that it's going to be done by XYZ date.
Right.
Because if you're planning on renting that condo out for the season and it's not done.
Yeah, we've done some on new construction that had a penalty for each day they went past because they rented a place, or they'd have to stay in a hotel or whatever. And it gives a contractor an incentive. They don't like it, but
well, what I say is, let's be conservative. Mr. Contractor, you say you're going to need 4 months. I'll give you 5.
Right.
We're starting in May.
That's right.
I'm going to have more than enough time to get this done before, my rental people are coming down. And so then if it's not, you can claim damages because the property wasn't done. And the key thing is to get your attorney's fees and court costs back. Sometimes you can get punitive damages in some rare situations. But I think the point here is and I'm sure I said it before, construction liens are a creature of statute, which is a fancy way of saying if every I isn't dotted and T isn't crossed,
they don't have a valid lien.
They may not have a valid lien.
Right.
Now, the court will give a lot of leeway to hardworking, reputable contractors and people. You made a slight mistake.
Right.
You included $10,000 worth of profit in a $200,000 lien. It's an oversight.
That's right.
But if your whole lien was for something that's not lienable, no, you're out of here. So, and the case law does tend to go towards the owners, towards the property owners, surprisingly.
Yeah, what I suggest to our clients is always be checking for liens, especially after they close on something or before, or if they're selling a property, because you don't want to have these problems arise. And they, like you said, they can go to the clerk's office and do their own search.
Sure, you don't even have to physically go. I mean, if you go, the clerk will assist you.
Right, but you can go on the computer.
Right, you can go on the computer at 3 in the morning.
It's very friendly. And then if you find one, call you. So.
Well, call a Florida attorney for sure.
Well, thanks for coming on, and I tell you, this was very useful for myself, and I'm sure it is for our viewers too. So
Great.
hopefully you come back again.
All right, well, thank you so much.
Thank you.